Hello, and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt. In this episode, I'd like to discuss some really welcome relief provided in the Secure 2.0 Act for plan sponsors, allowing them much more flexibility to correct plan qualification errors. As anyone who works in employee benefits knows, mistakes happen. Qualified retirement plans and the laws and regulations governing them are very complex. This is great for lawyers, right? But it's not so great for plan sponsors who are trying to just simply offer retirement benefits to their employees. And administering these plans is not an easy task. But what is easy is to make an error in administering the plans or keeping the plans documents always up to date. Before the Secure 2.0 Act was signed into law, the IRS had already recognized that plan errors occur. And so the IRS provided the Employee Plans Compliance Resolution System, also known as the EPCRS. And the EPCRS provided a framework for correcting plan errors. And there were really two options for plan sponsors. First was self correction, and the second was the voluntary correction program. So under self-correction, that means kind of what it sounds like. An employer could self-correct an error without making any filing with the IRS, without raising your hand and saying you had an error. You could just self-correct the error on your own. Self-correction was available to significant plan errors, and that is errors that involved a significant amount of plan assets or significant amount of plan participants or other facts and circumstances that would deem the error to be significant if the error was self-corrected within 3 years of the error occurring. So the error had to be corrected by the end of the third plan year following the year in which the error occurred. If an error was insignificant, it could be corrected at any time, provided that it was corrected before the IRS discovered the error and forced you to make a correction. And so in advising plan sponsors, we always had to make this determination of whether this error is significant, whether we can take the position that it's significant or insignificant. Of course, we always wanted it to be insignificant if the error occurred more than 3 years ago. So there's this concern of whether the error was eligible for self correction. The other correction option, of course, is the voluntary compliance program, and that's where a plan sponsor files with the IRS to basically get the IRS to agree that the correction method being used is acceptable to the IRS. And the VCP program gives you certainty that the IRS will agree that you properly corrected the error. So then the Secure Act 2.0 was enacted at the end of 2022, and it didn't replace the EPCRS, but it greatly expanded it. Plan sponsors have much more flexibility now with respect to self correcting plan qualification errors. Under the Secure 2.0 Act and IRS guidance provided in Notice 2023 43, any eligible inadvertent failure may be self corrected at any time, regardless of whether the error is significant. I'd like to say that again because those of us who have been doing this work for a long time were so tied into this concept of whether the error is significant or not, have to wrap our brains around the fact that that no longer is a consideration. We no longer have to be concerned about whether the error is being corrected within 3 years. Any inadvertent failure may now be self-corrected at any time, regardless of whether the error is significant. This relief is so sweeping that it may be easier to kind of think about what may not be self-corrected under this new regime. So, first of all, an error may not be self-corrected if the IRS discovers the error before the plan sponsor begins correction. So the facts and circumstances must demonstrate that the plan sponsor is actively pursuing a correction before the IRS discovers the error. I think now it's really important that if you discover an error and you want to begin self correction, that when you engage your service providers, such as your lawyer, that there's a formal letter or memorandum that explains the error and makes it clear that we have started taking active steps to correct the error. That is the marker that you can set down so that the IRS discovers the error while we're trying to get it self-corrected, that we have already started working on this and we are still eligible to self-correct the error. Also, an error may not be corrected if it is egregious, if it relates to the misuse of plan assets, or if it relates to an abusive tax avoidance transaction. A failure to adopt a written plan document may not be self-corrected. An error with respect to a terminated plan may not be self-corrected if it is significant. And so this is the one area, terminated plans, where we have to again think about whether the error is significant. And you may not correct an operational failure, and that's a failure where the plan is not administered in compliance with the plan's terms. You may not correct an operational failure with a plan amendment if the amendment is less favorable to plan participants. On the flip side, that means that if you have a plan error that was more favorable to participants, you may self-correct the error with a retroactive amendment, no matter how many years back that it goes. So if you started offering a higher employer contribution, if you expanded the eligibility rules for participation in the plan, if you started using a definition of compensation that increased the amount of deferrals or matching contributions made to the plan, those errors, if that was done without amending the plan at the time, those are errors, but they may now be corrected with a retroactive plan amendment. So other than those items that I listed, pretty much any other failure, whether significant or insignificant, and regardless of how long ago it occurred, may be self-corrected. It is important, however, to commence the correction within a reasonable period of time after the error is discovered, and then document again that the process for correcting the error has begun. And again, if the IRS discovers the error before that correction process is started, this relief is not available. So in sum, it's a new day with respect to administrative errors and the ability to self-correct those errors. It's very welcome relief from Congress, recognizing that keeping these plans administered 100% correctly, to have perfection in plan administration is, if not impossible, it's very difficult. And so this is very welcome relief to allow us all to breathe a little bit easier, and self-correct these errors. That doesn't mean we should be complacent, however. Again, the errors need to be discovered. They need to be corrected. You need to start correction within a reasonable time after you discover the error, because you don't want the IRS to discover the error before you start correcting it or even know about it. So that'll wrap up our discussion of this welcome relief under the Secure 2.0 Act. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.